Hello, my name is Cassie Houston, and I'm the legal director at Rocky Mountain Victim Law Center. I'm pleased today to be able to share with you some exciting updates that were made to the Colorado Victim Rights Act during the 2022 legislative session. First, I want to provide a brief overview of Rocky Mountain Victim Law Center and our services. RMVLC is a nonprofit law firm based in Denver, but we provide free legal services to crime victims across Colorado. Our services include 3 programs. First is our Victim Rights Legal Services Program. This is the program RMVLC was founded on more than a decade ago and advocates for the rights of crime victims in criminal cases under the Colorado Victim Rights Act. Our attorneys and advocate staff are able to assist victims as they navigate criminal cases and provide representation in those cases to uphold their VRA rights. RMVLC also has a Title IX legal services program where we are able to provide representation and services to survivors of gender-based violence in educational settings. This includes K through 12 and higher education. Also, we have our Legal Information Network of Colorado program, or LINK. LINK is a comprehensive program that provides legal information and some representation to crime victims on a variety of topics related to their victimization. LINK services are generally focused at civil legal issues such as housing, replevin, property issues, debt collection, some assistance with protection orders, and services such as that. Through LINK, we also provide extensive training and technical assistance to other victim service providers around the state, including a 2-day navigator training that is upcoming in September of 2022. In addition to our direct services programs, RMVLC also provides training and technical assistance, like this training today, and also one-on-one assistance with cases to service providers around the state, both legal and non-legal advocates. All of our services at RMVLC are free. We don't do any income screening, and the main criteria for qualification for services is that someone is a victim of crime and their legal issue is related to that victimization. If you have any questions ever about our services or referrals, please don't hesitate to reach out. Today, I'm providing updates on changes that were made to the Victim Rights Act through Senate Bill 22049 in the past legislative session. The efforts that were made and the success of this bill would not have been possible without the staff of the Colorado Department of Criminal Justice Office for Victim Programs, and in particular, Kim Branham and Kelly Kissel, and also the bill sponsors who really prioritize the importance of rights of victims in Colorado. Those bill sponsors included Senator Rhonda Fields, Senator Bob Gardner, Representative Kelly Tipper, and Representative Terry Carver. We are incredibly grateful for the efforts that were made by everyone on getting this bill passed. As a foundational point, I just want to pause and look back at the constitutional amendment that is the Victim Rights Act in Colorado. As a reminder, the Victim Rights Act is part of our state constitution and has been since 1992. The statutes that flow from the constitutional amendment and the changes that were made in the session this year are all related to these core rights of the right to be heard when relevant, informed, and present at all critical stages of the criminal justice process. As victim survivors and service providers have identified gaps in these rights and more needs for victim participation throughout the criminal legal system, additions and updates have been made to the Victim Rights Act to make it as robust and helpful as possible to ensure victims can fully participate in criminal cases. There was also no change made to the legislative declaration for the VRA this session, but it's also important to note that the changes made do also very much point to the purpose and intent of the VRA as was laid out by our legislature in 1993. Of particular importance, it's always good to remember that the purpose of the VRA is to increase the full and voluntary cooperation of victims and witnesses. And it was very clearly noted that such participation and cooperation is imperative for the general effectiveness and well-being of the criminal justice system. All the changes that were made this session particularly make it easier for people to participate, to feel like they can more safely and fully cooperate and be involved in criminal cases. We also always like to highlight an important part of the legislative declaration that all of the rights under the VRA are intended to be upheld in a manner no less vigorous than the protections afforded to criminal defendants. These are substantial and important rights, and making sure that we continue to improve on them to ensure victim experiences in the criminal legal system is robust and safe and well protected is a vital part of legislative efforts, such as what happened this year. So starting and diving right into some of the key updates that occurred this year. Under the Victim Rights Act, a definition of a victim has always included victims of certain crimes that are listed and enumerated under the statute. Most of these are in general crimes against people versus property crimes, nonviolent crimes, what we typically think of as nonviolent crimes. And over time, there's been more and more crimes added to that list to ensure people who are experiencing the impacts of crime and are victims of those crimes do have access to the rights under the Victim Rights Act. This year in this legislative session, 3 new crimes were added to the list, including second-degree burglary, first-degree arson, and criminal invasion of privacy. This important expansion of the crimes that are eligible for rights under the Victim Rights Act ensures that victims and survivors of these crimes in particular will also be able to fully participate and cooperate in the criminal legal system. I also want to note that in 2021, there was also an addition to the VRA of bias-motivated harassment, and also retaliation against judges, prosecutors, or jurors were also added as crimes that are listed under the Victim Rights Act. Another very important change that happened this year to the VRA and the definition of a victim is a clarification that the rights of crime victims apply to one or more people if the victim is deceased or incapacitated. The standard definition of victim under the Victim Rights Act, if someone is deceased or incapacitated, which can also be meaning they're under 18, means that the rights, the VRA rights of that person then extend to their family members, their spouse, their partners, parents, legal guardians, children, siblings, grandparents, and other lawful representatives. We saw numerous people who felt like some family members were able to access this right and participate fully in the process, but others were not allowed to. And we were seeing a pattern where one person in the family might be designated as the kind of conduit and main victim for the family. The change in this year's legislation around the VRA really clarified that these rights are supposed to apply to more than one or more people. If multiple family members of a deceased victim would like to provide victim impact statements or get notifications or have their specific position on plea offers and things like that provided, that each of those victims does have that right to participate. We also see this significantly in cases where there is a minor victim and there might be an extended or blended family where maybe one of the parents is getting notifications and participating, but the other parent or step parents might not be involved and want to be. This important clarification makes it clear that it is the expectation that everyone who is by definition a victim of someone who is either deceased or is incapacitated or a minor does have these same VRA rights. So we appreciate this distinction. It will address a lot of the concerns that we've seen raised by multiple family members in cases around the state for years. The next area of law where there were substantial changes this year were related to the right to be present. Through the success of expanded court access during COVID, it really created a great opportunity to ensure that victims not only have a right to be present at all critical stages of the criminal legal process, but that right to be present can include in-person, phone, or virtual participation by audio or video or similar technology. So throughout the VRA now, you will see that language everywhere that it notes that victims have a right to be present for a proceeding, that they can be present by phone or virtually or by similar technology. So that leaves the door open to whatever might be down the line, the way people could participate. We have seen some courts who are still asking that people file a motion to request this access. We do believe the way that the VRA was written and the updates that were made this year is intended to ensure that it's something that is just offered and available to victims based on the technology available in each courtroom. And having that expanded access provides a lot of additional participation, opportunities to attend hearings where there might be barriers with transportation or childcare or safety. And we are just thrilled that this was an addition that was made throughout the VRA this year. The other large change that was made related to the right to be present is related to sequestration of a victim. Generally, there's very strong law and very strong rights under the VRA that victims have the right to be present for all critical stages of the criminal legal process. However, sometimes courts decide they can be sequestered, particularly if they're also a witness or it's a hearing where there's testimony being taken and they might testify later. If the court decides that a victim should be sequestered from a hearing, the VRA now has the addition that the district attorney is now required to undertake their best efforts to minimize the time the victim is excluded from the courtroom. This often looks like things like calling them as a witness first, making sure they're the first witness in a case so they can then be present for the remainder of the proceeding, or working collaboratively to try and find ways to ensure that they are in the courtroom for as much time as possible. Another really important change that occurred this year was related to bond modification hearings. I want to note that this and many of these other updates were the direct result of victims and survivors who advocated for and raised issues, brought forward concerns about ways they were treated in the system, and then helped identify loopholes and places where their rights could be upheld in a more meaningful way. Prior to this year, victims of crime always had the right to be heard by the court as to modifications of a defendant's bond. There's no right now for victims to be heard at the initial bond setting, but the right to be heard about any modification of the terms or the amount or the conditions of bond was something that always existed. However, there was no previous requirement that a bond modification have a hearing, which meant it could be modified. A victim would have the right to be heard, but there was no place to be heard at. So this very important change this year made that adjustment to ensure that if it's a VRA crime and there's a request to modify a defendant's bond, there has to be a hearing set so that a victim's right to be heard can actually be enforced in a meaningful way. This is particularly important in regard to safety considerations for many victims. And one of the cases that was brought to the attention of many of us doing this work was specifically related to making sure that a court was aware of some really unique safety concerns in a case. And when that didn't happen, there was increased safety and danger to the victim and their family. So ensuring that a victim can actually address the court directly, the victim who's often the best expert on the risk that a defendant poses to them or other folks, are able to actually address the court and ensure the court has all of that information, and considering a bond modification is incredibly important and was a huge change and a good cleanup that happened in this year's legislation. The other area of rights where there were some substantial changes was related to the right to consult with the prosecution. The Victim Rights Act has a longstanding right to consult with victims about any plea offers that are extended to defendants prior to that being extended. It's always been very important to note that this is a right to consultation, not to notification. So it has never been a right just to be informed of what plea offer will be extended. It's always been a right to actually have a conversation, to provide some input, to provide some thoughts on what a victim would like to see the outcome of a case be, and how their feelings are on a plea offer, getting a good understanding of what that means. That right to consultation regarding disposition of cases now includes a consultation before any diversion offers also. So pre-file or post-filing diversion offers, which previous to this were not explicitly listed as a place where there was this right to consult. But it now requires that in those cases too, with diversions, that the victims in the case will also get a chance to know what's happening, to voice their opinions about the diversion offer, and to participate more fully in that process. Also, an important addition based on specific feedback from victims and survivors about how difficult it is to talk about a plea offer, understand a plea offer, and then particularly when someone is sentenced to the Department of Corrections, find that the plea that was reached and the sentence that was entered is not actually the time someone serves. So this addition was made this year just for sentences to the Department of Correction, that a consultation about a plea offer must also include an explanation that the defendant might not serve their entire sentence in prison because of earned time and good time. This is a huge step in increasing clarity and transparency around sentencing for victims, so they can understand when they hear there's a plea and a sentence to 10 years in the Department of Corrections, it's not really going to be 10 years. Another important change that was a direct result of feedback of victims and survivors was around the access to a free copy of an initial incident report. That right has existed in the VRA for a long time, but frequently we were hearing from people that they were requesting incident reports for help with a lease break letter or protection orders, custody issues, insurance claims, things like that. And the incident report they got was so redacted that it was essentially useless, just essentially a page of black text. This now very clearly clarifies that in order to ensure this free initial incident report that's provided, is useful and meets some of the purposes that a victim and survivor has for requesting that, it needs to include the victim name, the offender name, the date of the crime, the charges, and a summary of the incident. That can be very brief. That might be the only thing that's provided in this initial incident report, but this does now require at least that much information is provided, which allows it to be a useful and helpful document for other victimization related legal needs and other needs. Some additional important things to note about this: the law enforcement agency can redact the names of other victims involved in the incident and other witnesses who are not related to the person requesting the report. And they can redact their personal identifying information as well. And then a last important piece on the privacy aspect of this, there is now a requirement in the VRA that the law enforcement agency needs to inform the district attorney that a victim requested an initial incident report and what information they received. And if the case is open and moving forward and there's discovery happening, the district attorney then needs to provide that information to the defendant so that they're aware of what information the victim was provided as to the initial incident report. Another very large change that happened this year, specifically related to victim privacy, was around the subpoena for victim records. There has long-standing been a right in the Victim Rights Act for victims to be informed if a subpoena is filed for their records, and a right for them to be heard by the court as to how they feel about that subpoena, particularly for records that are privileged, where it requires they actually waive that privilege before they should become part of a case. Even though these rights have existed and the right to notice and the right to be heard on that have existed, we were finding and hearing extensively that a lot of service providers and record holders were providing records automatically when they got a subpoena, not realizing that there was additional court determinations that need to be made, that waivers of privilege might be required. And frequently it's things like private therapists or smaller service providers who don't have access to legal counsel or don't have anyone to help make sense of what a subpoena is, and that it's a request for records, but not a court order. So this very important change happened this year to try and address some of that and try and prevent records from being disclosed and becoming part of a case before they should be. What this now includes is that when a subpoena is served for victim records, the person requesting the records must file a certificate that says it was filed in good faith and for a lawful basis. For example, you can't just request a victim's records to try and locate them, or for something unrelated to the case entirely, or something that might benefit in a civil case but isn't part of the criminal case where they're being requested. The subpoena must now also require notice that tells the record holder that they are not to release the records until there's a court order. So that's really pointed at that issue that I was discussing, where record holders would get a subpoena. It looks like a very legal, formal document, and then immediately just turn over the records of a victim without realizing they didn't have to. So this gives some additional notice and addresses that issue specifically. There's also a requirement now that the person requesting the subpoena needs to file a motion with the court explaining why, and if it's privileged records, explaining the basis for believing there's a waiver of that privilege and that the records can be part of the case. Once the subpoena is issued and that motion is filed, the court now also has to make specific findings before they can say the records can be released and become part of the case. This includes determining that there is a waiver of privilege, that the records exist, that they're relevant to the case, that they can't be otherwise obtained, and that the requesting person actually needs the records to prepare for trial, that they are part of the case. If the court decides all of those are true and that the records can be part of a case, they then order the release, and then the record holder needs to produce them within 7 days. So this is a really great protective measure for the privacy of victims to make sure that they are still maintaining some control over their private and privileged information in criminal cases, and having some of these safeguards put in place to ensure those extra protections. We know this is an area where there's often a lot of questions. There always has been. Subpoenas for records and victim privacy issues is the number one issue of technical assistance calls that we get. If you're looking at this and it's confusing and you have more questions today, or 6 months from now or a year from now, do please feel free to reach out to us. We're always happy to talk through this, whether you're a service provider who is a record holder or someone just trying to give information to someone you're working with on what their rights are under the Victim Rights Act as it relates to subpoenas. Next, there was some changes and some cleanup done to some post-conviction rights around information sharing. These were both really truly cleanups that were necessary and important as a result of a large change to the Victim Rights Act that happened a few years ago. And until fairly recently, victims in post-conviction settings, so after someone was sentenced, so while they're on probation or in prison or in community corrections serving some kind of sentence, until fairly recently in the last few years, victims had to request notifications in that phase. So all notifications up through a trial, sentencing, the end of a case would be automatic, but as soon as the post-sentencing stage happened, you used to have to opt in to request them. With the change a few years ago, Colorado really led to the forefront nationally of making a big change, saying those notifications should also be automatic. You should only have to opt out if you don't want them. They should happen naturally and without someone going out of their way to request those updates. Probation cases are excluded from that, and they were not have not yet been included in the automatic opt-in. But other types of post-sentencing notifications now do happen automatically. When that change was made, there was a realization that notifications in cold cases then became opt out instead of opt in, which meant there was a huge risk of very, very old cold cases, family members, surviving family members and people with victims' rights just getting calls, 10, 20 years after the fact saying, we believe we now have to provide you with an update in this case when someone may not have asked for that. Because that was such a unique type of case, this was a cleanup made this year to specifically say that updates related to cold cases where there's a statute of limitations over 3 years will only now be provided upon request. So it's not that automatic providing notification in case unless someone wants it. Similarly, when that change was also made, there was one section of the statute that wasn't changed, where it used to say that you had to request the Department of Corrections to protect and not disclose victim information. This now changes it so that happens automatically, that a victim and family does not need to request the Department of Corrections to protect their information. It will just happen automatically. We know in practice that's generally what was happening, so this was just truly a cleanup of the statutory language. The last changes that were made in this legislative session were, one was related to the defendant requiring to be present during a victim impact statement at sentencing. This was a very strongly led victim and survivor led effort to say, we have seen cases where particularly where the sentence isn't, everyone knows what it is when you walk into sentencing, where defendants were just not participating and weren't appearing. And that might often be a space where that's the only place a victim or their family is able to actually talk about the impact of the crime. And if a defendant is opting just not to be present and to participate in that sentencing, it felt like it took away a lot of the meaningfulness of providing those victim impact statements for a lot of people. So this is a change that now requires a defendant to be present. We do believe this could be done remotely potentially, but they are required to be present while victim impact statements are presented at sentencing unless excluded by the judge. So this is also another very important change that was directly a result of advocacy and great work by victims and survivors across Colorado. Another really great change around accessibility and participation in the legal system is that translation and interpretation now must be provided at critical stage hearings throughout the criminal legal process. So at hearings now, by coordinating with the district attorney's office in advance, if a victim or survivor is planning to attend and participate and they need an interpreter, they can then request that, and that now has to be provided under the Victim Rights Act. It is by statute a coordination through the DA's office. There is a requirement and some language in there about providing enough time to actually make sure that's in place, but this does increase access so people can meaningfully attend and participate in all of these hearings now in a way that they weren't able to before if there weren't translation and interpretation services. We are excited to have been able to share these updates with you. I hope this is helpful. If you have more questions about any of these, please do feel free to reach out to us at Rocky Mountain Victim Law Center. You can reach us at 303-295-2001 or by email at info@rmvictimlaw.org, or you can contact us through our website or get more information about our services there at rmvictimlaw.org. Please do reach out if you have more questions about any of these updates or anything else, and we thank you for your time.